Thank you very much for having me today with all of you. I mean, it is a pleasure, even if we are so far, but I mean, so close at the same time. So, okay, I'm going to try to talk a little bit about something actually very specific, but I think very interesting too. So we could yesterday hear something about the European Order of Payment, proceedings. So general questions, but today I'm going to focus on a very specific question, that is the relationship between the European Order of Payment proceedings and the protection to consumers. That, I mean, we could say that in the beginning, the European Order of Payment regulation and all the proceedings trying to, to assure creditors to obtain, this order, this, quick and safe tool to recover the money that, they owe. Without engaging them in difficult transnational proceedings, has nothing to do with consumers, or at least it wasn't very worried about consumers. I mean, the concerns of the European legislator at the time where they used the regulation wasn't there. I mean, they didn't focus on protections consumer. They just, as we are going to see now, they just were focused on trying to get the money so quick and so easy as possible, and through the European Order of Payment, when there is a transnational, thing, no, a transnational situation here. So this doesn't mind that the consumer situation in a business relationship, or actually in a consumer relationship, has nothing to do with the European Order of Payment. But this wasn't so clear at the beginning, or this wasn't so clear for many years. But then a judgment of the Court of Justice of the European Union came, Bondora. We're going to talk a lot about Bondora in the following minutes, that put on the table the situation of consumers in European orders of payment, and actually the way of concealing the protection given to consumers in European law. I mean, like a general rule, or like general desire, actually like a fundamental right for citizens in the European Union, and these other goals that try to achieve the European Order of Payment procedure. So let's start with protection to consumers. I mean, let's see what does the European law says about consumers' protection. It is important for European law. It is not important. I mean, it's a main goal. Of course, since the title of the slide is here, you can see that it is a goal for European law. I mean, it is such an important goal that we can find this policy between or among the fundamental rights recognized in the Charter of Fundamental Rights of the European Union. So if we go to Article 38 of the Charters of Fundamental Rights of the European Union, we can see that there is a statement there relating to union policies that shall ensure a high level of consumer protection. I mean, shall ensure, as we have seen now, this English term, this English form, to make clear that it's an obligation for the Union, for the European Union, to take into account consumers when the European Union designs their policies, their regulations, or their law, actually, and trying to achieve this high level of consumer protection. So the case law of the Court of Justice of the European Union has been very persistent in trying to remark this protection to the consumers into the European law. So the Court of Justice, at the same time, or like the European law makes, is very conscious about what is the consumer's position in a relationship of consumer. So when we as consumers go to the market and we try to buy I don't know, a service or a thing, we don't have the same power that the seller or that the provider of the services. So if we think when, I don't know, when we go to a financial institution, when we go to a bank, or when we try to hire, I don't know, our phone line or our light or energy power company, and we try to see which are the prices, which are the conditions or the terms of the contracts that we sign in this kind of relationships. The thing is that we as a consumers, we don't have a real bargaining position here. I mean, we don't have the power to change the policies of the companies, or we don't have the power to negotiate vis-a-vis with the seller or with the supplier. We just accept what they do. I mean, we just accept what they propose to us. Probably we can choose like 2, 3, 4 different kinds of contract, but we don't have as consumers a power to bargain, to negotiate vis-a-vis, as the Jasmine Bohotov says here, this equal position with the provider or with the seller of the goods or services. So since the community law, since the European law realizes that what demands our position as consumers is having a high level of protections from the European and even from the national authorities. So this is like the first principle that we can see here. This principle comes from the Article 38 of the Charters of Fundamental Rights, and at the same time, this principle has been recognized by the case law of the Court of Justice of the European Union. So, taking or departing from here, there is a very interesting directive, Directive 93 of 2012, that serves to protect consumers for unfair terms in contracts. So this is a very important piece of legislation, a very important piece of legislation that has been repeatedly applied by the Court of Justice of the European Union, and that basically what intends this directive is protecting consumer in this unbalanced relationship, in this unbalanced commercial relationships. So what the directive tried to do is actually protect and then forbid unfair terms in contracts made between a consumer and a company. Okay, so in this case, the directive tries to avoid companies including unfair terms into the contracts that they sign with consumers. What is an unfair term in this scope, in this field? An unfair term here is a contractual term that, as the Article 3.1 of the directive says, has not been negotiated individually between the parties, I mean between the consumer and the provider, and causes a significant imbalance in the parties' rights and obligations. And this balance, obviously, is not in favor of the consumer, but in favor of the company, in favor of the provider or of the seller. So when there is a term in a contract that provokes that the consumer has less rights than the provider, this type of contractual term is considered like unfair, and so we are going to see that this is not binding on the consumer. So it is for the company and for the authorities actually, and we are going to see for the courts, national courts, but even European courts, these kind of terms are going to be considered as null or as not binding to the consumer. I mean, let's think, I don't know, credit cards. I mean, let's think about unfair interest in credit cards contracts. I mean, like the company charging an excessive interest when we have red numbers in our credit card, for instance. So these are the kind of terms that are considered like unfair by the directive, and that are considered like unfair by the case law of the Court of Justice of the European Union. I mean, we can see that actually in, I don't know, telecommunications company, phone companies that establishes I don't know, harsh penalties on consumers for, I don't know, for letting go the contract before the signed time. For instance, with these terms like you need to be my client for a whole year or for 2 whole years, and so on. So these are the kind of terms that included in a consumer contract are taken by not binding, sorry, on the consumer's part. Okay, so we have then the definition of the unfair terms. We know that these unfair terms are not binding on the consumer, but there is actually also an active role or an active obligation for the member states, because the member states have to not only to respect the directive, but to put the means to make this directive or to make the consideration of this directive like effective in reality. Okay, that's the reason why Article 7 of the directive says that member states shall ensure that adequate and effective means exist to prevent the continued use of unfair terms in contract concluded with consumers. So there are many ways of doing this, like, I don't know, administrative authorities taking care of consumers' rights, but also we're going to see that a very important part of this protection has to do with the role of national courts. So national courts, as I mean, repeatedly, the case law of the European Court of Justice has stated, have a duty to protect consumers and to compensate the imbalance existing between the consumer and the provider, the supplier of the services or the seller of the goods. And you have here in the slide some of these decisions taken by the European Court of Justice or the Court of Justice of the European Union, but all they go in the same way, I mean, in the same sense. That is that the judges are not just expected to wait for the consumer to claim the unfairness of the term, but they have to take an active role. And so they have to take care of the consumers, even when the consumers have not conscience or are not conscious of their rights or are not conscious of the unfairness of the terms included in the consumer contract. Okay, so this is, let's say, the general principles, or these are the general principles included in the directive, and that the case law of the Court of Justice have taken from there. And at the end, as I said, there is a need for the national courts to examine these kind of issues, to examine the unfairness of the eventual unfairness of contractual term, even of their own motion. I mean, ex officio, without, as I've said before, without waiting for the consumer to claim the unfairness of the term. Ever or always that they have, I mean, that the courts have the legal and factual elements necessary for that task. And I mean, this is important, this last part of the sentence here. It is important because we are going to see later when we are going to look or to take a look to the European Order of Payment Proceedings, that the possibility for the judge to take care or to examine this kind of unfairness or unfair terms is conditioned to the possibility of having the factual elements necessary to make that control. So we are going to see that in reality, it means that they need to have the contract, or the national courts or the courts, in order to control the unfairness of these terms, they need to take a look to the contracts, and they need to examine these contracts. And this is not so easy when we talk about European Order of Payment Proceedings, because if you remember what we saw yesterday, European Order of Payment Proceedings doesn't require, in principle, to give an evidentiary or to give a document with the claim or with the initial petition or the initial request of the proceedings. So this is something that is going to be important, and we are going to talk about it later. Okay, so protection to consumers. Protection to consumers was adapted to the Spanish law, and I'm going to make a little incursion into the Spanish domestic law, but just very brief, and you're going to see that it makes sense for the reasons I'm going to say later. Okay, so there was a judgment in 2012, the Banco Español de Crédito, and another one in 2016, Final Madrid, related with the possibility of protecting consumers in domestic Spanish order of payment proceedings. So the thing is that the Spanish proceedings in the domestic order of payment didn't foresee any kind of procedure for the judge, for the court, to examine the eventual unfairness of a contractual term, even when the Spanish proceedings were documentary proceedings. There is a slight difference, not so slight, between the Spanish domestic order for payment proceedings and the European order of payment that has to do with the documentary character of the initial petition. For asking for asking an Spanish order for payment, the applicant needs to show somehow in a document that he owns the debt, that he has some reasons to ask for the debt, to claim for the debt. It doesn't happen, as we know, in the European order for payment. And even thought the proceedings, the Spanish proceedings, didn't provide any way for the court to make the control about the unfairness of the terms in which the debt could be based on, or could be grounded. Okay, so these judgments that I have shown you here said that, this was against European law, that taking into account the directive that we have seen before, and taking into account the duty for the domestic courts to make an examination on unfair terms, even of their own motion, the Spanish law, the Spanish proceedings were against the European law. So the Spanish legislator made a reform on the domestic proceedings. Okay, so the Spanish order for payment proceedings were amended in 2015, and this amendment made that a specific procedure was included. Okay, so I was saying the Spanish legislator included an amendment in the Spanish law, making possible for the judges to examine the eventual unfairness of terms of their own motion, and actually including a hearing to the parties if the judge considered somehow or at an initial consideration that the unfairness was there. So this changed actually the speedy and the easy character of the order for payment, Why? Because, as you know, I mean, it happens the same in every national legislation and in European order for payment. The for payment is issued before hearing the defendant. So, including a hearing, even if this hearing is limited to the considerations about the unfairness or not unfairness of the contractual terms with consumers, is changing the structure of the European or of the order for payment. Why? Because we are including a hearing to the parties, and we are giving voice to the defendant before issuing the order for payment. After that hearing, the judge was to decide if the contract where the claim was based on was unfair or not. And if the terms happened to be unfair, so the judge could do actually two different things. Dismiss the petition, I mean, not issuing the order for payment, or even to continue with the proceedings, but taking out of the contract the unfair terms. And like, I don't know, if the unfair terms were related to the interest, not to the principal amount of money claimed, so taking out the interest. So even the judge could change, or he will be able, or she will be able to change the quantity, the amount of money asked by the petitioner, without, I mean, or by making out or taking out of the contract these unfair terms. Of course, if the terms happen to be fair, the order of payment could be issued, and I mean the proceedings continue like that. I mean, issuing the order of payment, and then given the specific amount of time, the term for the defendant to pay, to confront, or whatever. Okay, so this is what happened in 2015 in Spain. As you can see, the change was important for the structure of the Spanish order for payment proceedings, because, as I said, this included a new procedure, or a specific procedure to take into account the eventual unfairness of the contractual terms in the case where the defendant was a consumer. Okay, so the consequence is that the payment order proceedings lost some agility in this case, okay, in the case where the defendant was a consumer. So what happened here? What happened is that in the following years to this decision, to this judgment of the Court of Justice, the European Order of Payments applications in Spain grew in a very dramatic way. So we can see that in year 17, in Spain were issued 655 petitions of European Order for Payment. As you can see, the next year, the following year, I mean, the increase of the petitions was spectacular. So, because we passed from 600 to 5,000 or almost 6,000 of requests for European orders of payment. And even if we go to the following year, the year 19, the increase was even more spectacular, taking or leading us to the amount of almost 30,000 petitions of European order of payment. So since that, I mean, the amount of petitions is also big, I mean, it's also high, but I mean, the increase or the growth has stopped there. Okay, but why happened this in Spain? Has this something to do with the new regulation of the domestic order for payment in Spain? I mean, let's see what happened in Europe in these years. I mean, I only have data, or I only couldn't find data for the 2018, but we can see that meanwhile in Spain in 2018 there was a spectacular growth. It didn't happen in other countries. It didn't happen in Germany. even in Germany, we can see there is a decline of petitions. It didn't happen in Ireland, it didn't happen in Lithuania, it didn't happen in Portugal, it didn't happen in Luxembourg. I mean, it didn't happen in any other country in Europe. So at the same time, the domestic European order of payment didn't grow so fast. I mean, we could say, okay, there was a growth for the European order of payment, but also for the Spanish order of payment. But it didn't happen like that. I mean, we can see a little increase. Probably we can blame that to the economic situation of the country, so on. But I mean, nothing to do with what happened with the European tool, with European proceedings. Okay, at the same time, we can see that the effectiveness of the European order of payment, the domestic European order of payment, that was so successful at the beginning of its existence. I mean, we only have domestic order of payment since 2000, and at the beginning was very successful. And I mean, we can say it is still successful, but not so much. And probably it is not so useful for the companies, because as I have explained before, for companies, it was so easy to use the order for payment, the domestic order for payment, before the before the judgments of the Court of Justice, but it was not so easy after that. Why? Because this new procedure taking into account the eventual unfairness of the contractual terms. So we find that if we look to this increase that took place in 2018 and 2019 too, we can see that this increase has to do with consumer contracts, and specifically among these consumer contracts with credit cards companies, with banking operations, and with phone companies, that actually were not in origin transnational operations. They became transnational to avoid the domestic order for payment, to avoid this control about the unfairness of the contractual terms, and go to the European order of payment, where not such control was issued yet. So how companies did this? Pues then trying to pass, to assign receivables to vulture funds or to recovery of claims companies. So let's imagine a phone company in Spain who got a claim or got a debt against a consumer. So this company didn't want to use the domestic order of payment. So what these companies made was to transfer their debts, their credits, to foreign companies, vulture funds in some cases, recovery of claims company in some other cases, transfer these claims, and these companies were the ones who made the claims against the Spanish consumers through the European order for payment. Okay, so this is the situation. The reason why, I mean, I've said a little of this before. The reason why is for suppliers and for providers of goods and services, the European order of payment is easier to use than the Spanish order of payment. Why? Because the European order of payment doesn't need documentary evidence with the initial claim, with the request. So, I mean, it's just what you write on the form, and that's it. I mean, explaining the reasons, explaining the grounds, and so on, but you don't need to attach the document, to attach the contract with the petition, with the initial petition of a European order of payment. So you only have to explain the cause of the action and to describe the evidence supporting the claim, but only a description. So only an allegation, not an evidence, not the real document. Okay, so the purpose for this requirement that the regulation of European order of payment includes is just to identify the debt, to make possible to distinguish this debt from another debt, and also to make possible for the court make this initial assessment that we were told before about it, but not really to make a review or to make an assessment on the real grounds of the claim. That is something that is deferred to opposition, okay, to opposition proceedings. So when the consumer, when the debtor doesn't make anything, doesn't confront, doesn't make an opposition, so there is no real discussion about the grounds of the debt. Okay, so the examination is only about whether the claim appears to be formal. I mean, if what you are telling to me, what you, claimant, are telling to me, court, makes sense or doesn't make sense, and that's it. I mean, the court is not going to assess if that explanation is, it is in the contract or derives from the contract. I mean, that's, it makes sense. Okay. So after that, the court can request to complete or rectify the application. I mean, if the form is not clear, if the causes of the action or description of the evidence are not, of the evidence are not included, and that's it. I mean, we're going to see that these articles are going to be important for the following considerations that we are going to make. But I mean, what is in the regulation is this, and what has been applied till 2019, it was this. Okay, just a visual assessment of the claim. That's it. I mean, in contrast to this, the Spanish proceedings specifically, or sorry, not in contrast to this. So beside this, the Spanish proceedings on European order of payment is not only that they don't contemplate the possibility of attaching documents with the initial request, it is that specifically forbid joining documentary evidence to the application. So it's not like you don't need to attach documents to your initial request on an European order of payment. It's just that you cannot do it. Okay, so this is the this is the most important differences between the Spanish proceedings and the Spanish proceedings on European payment order. Okay, the consequence is that there is no procedure and there is no way to control the unfairness of the contractual terms funding the claim. And remember that the case law of the Court of Justice said that this control of the unfairness of the contractual terms funding the claim was conditioned to the possibility for the judge to doing that, to having the knowledge about the facts and about the law. And how can the judge have the knowledge about the facts if there is no possible to include the contracts, or even if there is no obligation to include the contracts in the claim, okay, in the initial petition. Okay, so traditionally, this control has not been made by the Spanish courts in the scope of European payment orders proceedings. So, the situation here, we have a domestic order of payment proceedings where there is a control about the unfairness of contractual clauses in consumers' contracts, and we have an European order of payment that even under the Spanish courts or under the Spanish proceedings don't request or even don't allow any kind of control about the unfairness of the terms, of the contractual terms for consumers. So this made some courts in Spain to ask to the Court of Justice of the European Union if this situation agreed with the European. So two preliminary rulings were issued by two Spanish courts, one in Vigo, the other one in Barcelona. So about the possibility to demand a copy of the contract to this company, Bondora, that was a company trying to collect a debt against a consumer, in this situation of transnational or forced transnational situation, because it was in origin a national debt that was converted in transnational after this transfer that I have explained before. So Bondura refuses to deliver the contract because Bondura says, I mean, I don't have the obligation, even I don't have the possibility under the Spanish law on European order of payment proceedings. So I'm not going to deliver the contract. I'm not going to allow you, judge, to control the eventual unfairness of the contractual terms that is in the basis of this collective agreement. Okay, so then the judges, the courts, made to the Court of Justice the following questions. First question, must the court control the fairness of the contract in its own in European order of payment proceedings? So this general rule that has been applied in general for the Court of Justice in some other kind of proceedings and even in domestic European order of payments is also applicable to the European order of payment proceedings. Second, in doing this, may the court request complementary documents to make this control? Because, of course, if the initial petition doesn't include any kind of document, how is the court able to do this control? I mean, it's impossible for the court. So the second question that these courts made to the Court of Justice of the European Union was, may I request complementary documents to the plaintiffs, to the claimants, in order to see if these documents show any kind of unfairness against the consumers? So this is the second question. The third question, I mean, arises by its own. I mean, so is there a conflict between the regulation of the European order of payment and the directive of on consumers protection? Because if directive on consumers protection makes an obligation for the courts to control the eventual unfairness of the contractual terms in consumer cases, and the regulation on European order of payment doesn't allow that, there is, I mean, a conflict there. How do we solve that conflict? And then, is there a conflict between Spanish law that doesn't allow the court to ask for new documents and the regulation on the European order of payment? So this is the other question. So don't make sense of that M. There is an extra M that I shouldn't write there. Okay, so this is the preliminary ruling, or this is the way how the Spanish court presented this preliminary ruling to the European Court of Justice. And the European Court of Justice, the Court of Justice of the European Union, made this or issued this judgment, Bondora judgment. So first thing here, the court recognizes that here we have different interests in conflict. The first one, when we talk about the European order of payment, we talk about simplify, speed up, and reduce the cost of litigation in cross-border cases concerning uncontested pecuniary claims. Okay, so what the European order of payment tries to do is to make simple for creditors to collect their debts, and that's it. So this is like the main principle here, and this is the reason why the European order of payment exists and is intended. Okay, so how does the European order of payment regulation makes this? First thing, making a reversion of the party roles in the proceedings. So as we know, in the European order of payment proceedings, it is not for the claimant to prove, to demonstrate that the debt exists. It is for the plaintiff to confront that request and to demonstrate that there is no debt, or at least to make some, or to take some active role, to make some active part to demonstrate or to at least allegate that there is no debt, or that debt is unfair, or whatever, has been paid, whatever. Okay, but there is a bigger responsibility for the debtor. Okay, and this is something that fits wrongly with the protection of consumers if we think that consumers have this unbalanced situation when we compare consumers with suppliers or with sellers of goods. Okay, so how are we going to protect consumers? How are we going to assure a balance between creditors' rights and consumer protection rights if we don't let consumers to make an allegation? I mean, of course, we let consumers to make allegations during the proceedings, but if there is no possibility for the court to make that controls. Okay, so if the judges must have an active role, an active intervention in protecting consumer rights, as we said before, and if efficiency cannot be got at consumer protection's expenses. So this is what the court. Sorry, I include an Spanish sentence here. I missed the translation, but I mean what the Profit Credit Polska judgment says is that opposition is not enough for protecting consumers' rights. I mean, we have goals in conflict here. Then we have on one side the European Order of Payment that tries to collect the debt no matter what. Okay, no matter what. And on the other hand, we have the Directive on Consumers Protections that tries to protect consumers and tries to make or to balance the position of consumers and suppliers. And this, as the opinion of the Advocate General in this Bondora judgment says, are goals in conflict. Okay, so once that the court shows up that there are this conflict, this interest in conflict, how does the court solve this situation? So the court says or states clearly that consumers must be protected even in European orders of payment proceedings. So the balance here between the principles that rule the European order of payment proceedings and the principles that rule the protection of consumers for the court are clearly balanced in favor of consumers. So what the court says is that national courts must carry out an ex officio review of possible unfairness of contract terms. So the same thing that was stated in a general scope is now specifically stated for European order of payment proceedings. And in doing this, courts may request, have the possibility to request from the creditor, from the person who is trying to collect the debt, additional information relating to the terms of the agreement relied on in support of the claim. So, when the plaintiff is a consumer, when the debtor is a consumer, the courts need to protect that consumer, and in protecting that consumer, the courts may request documents to the claimant in order to see if there are unfair terms inside that contract. Okay, this is what Profit Credit Polska says a previous decision. So there is a direct application of Directive 93/12, and it must be determined whether the later rules of the opposition proceedings give rise to a significant risk that the consumers concerned will not lodge the objection required. What the court says is it is not enough on protecting consumers with the opposition proceedings after the issuing of the European Order of Payment. So there is a need for the courts to protect consumers and not waiting for the consumers to contest the claim through the opposition proceedings. Why? Because it is possible for the consumers that they don't realize their rights, they don't realize that the terms of the contract that they have seen are unfair, or probably they don't have the means to confront or to oppose to the claim in terms of hiring a lawyer, paying the fees, and so on. So this is the reason why the court says that is compulsory for the court to make that control, and if the court needs to ask for new documents or ask for new information to make that control, it is possible for the court on doing this. Okay, so how in the proceedings can the court do this? So the court is going, the Court of Justice of the European Union is going to reinterpret a bunch of articles that we have talked before about them. I mean, first, Article 9. Article 9 of the regulation allows the court to request additional information. So the European Court says, okay, in this new information that the court may request to the plaintiff, to the claimant, to the plaintiff, it is included the possibility of requesting the contract in which the claim is based on. So in doing this, the court may look if there are any kind of unfair terms inside that contract. So this is the first thing. The second thing that the court says, I mean, it is not possible for the national legislation that applies the regulation of European Order of Payment, to forbid or not to admit the deliver of new documents or of additional documents if the court thinks that the court may have to do that. Okay, so this is what happened into the Spanish proceedings for issuing European orders of payment. That's, as I've said before, the Spanish proceedings made impossible for the court and even for the parties to attach documents to the initial file. So the court says, the European Court says, this is against the European law. Okay, this is against the European law. So it is not possible, as I said before, to defer control until opposition proceedings. Why? Because the control must be effective, and we are not sure if deferring control till opposition proceedings, this control is going to be effective, and it won't be effective since this may not happen. I mean, because opposition is not always happening. Opposition only happens if the defendant is going to ask for the opposition, if the debtor, if the consumer is going to ask for the opposition. And it may not happen because of the shortness of the term, because of the lack of information, or even because the lack of consciousness of consumers' rights in the part of the consumer. So, which are the consequences for this judgment or for this decision of the European Court? The first thing is that it won't be possible to issue an European order of payment if there is no previous control of consumer contracts. So when the relationship that is brought to the European order of payment is a consumer relationship, I mean, there is a duty to examine by the court the eventual existence of unfair clauses or unfair terms in the contract, that grounds the request, okay, that grounds the petition. So, an European order of payment application can be denied if documentation is not provided by the plaintiff or unfair terms are found. So, it is not only that the judge can control the existence of the unfair terms by reading the contract. It is also that since Article 8 and 9 of the regulation can be used for the court to request new documentation, the contract. If this new documentation is not delivered by the plaintiff, by the claimant, so it is a power in the court's hands to deny, to dismiss the European order of payment application. Okay, so we can see that in cases of consumers, European order of payment becomes a documentary order of payment. I mean, it loses their undocumentary character that is initially in the regulation, and it changes into a documentary order of payment. Okay. It means a modification of the principles and the structure of the European order of payment proceedings. I mean, there is a breach of simplicity. Simplicity lies down in order to make more important protection to consumers. Okay, so there are no forms for some of the proceedings that we have seen here for this new for the control of the unfair terms. There are no forms there, so the simplicity fails here. It is more difficult to automatize applications because some of the some of the evolutions that the European order of payment has had in the last year have to do with e-justice, with making these proceedings automatic, even with giving these proceedings to non-judicial authorities. So this is more difficult here because there are some decisions to take before issuing an European order of payment, and these decisions cannot be taken automatically, cannot be taken by a machine or by an artificial intelligence, because unless for now, the unfairness of the contractual terms must be assessed by a judge, by a person. I mean, probably we can find artificial intelligence in the future here, but for now, I think it's going to be difficult. So there is on the merits discussion before the issuing of the European order of payment, and this is absolutely contrary to the nature or to the principles that initially were in the regulation. Okay, this discussion on the merits, of course, has to do with the existence or not of unfair terms in the contract, in the consumer's contract. So, for consumers' debts, the European order of payment passes to be documented. Okay, the cause of the action and the basis of the claim are not anymore elements to identify the debt, but now they are evidentiary elements for the eventual upholding of the debt, okay, of the claim. So, it changes. It's not only the judge trying to, to assess if the explanation given by the plaintiff was right or not. It's an explanation that makes sense, or it is not an explanation that makes sense. It is actually a duty to assess these documents and to declare if unfair term is there or not. And by doing this, I'm afraid there is no way of doing this without hearing the parties. Okay, without giving some word to the parties to explain their reasons, why they consider or they not consider if there is an unfair term inside the contract. And this changes everything in the European order of payment proceedings, as it changed into the domestic order of payment proceedings in Spain, in Slovakia, in some other countries. Okay, this can have a deterrence effect for the use of European order of payments. And since when we say that one of the main problems that we have with the European order of payment proceedings, as we have with the small claims the European small claims proceeding, is that they are very rarely used. They are very not well known by the applicants, by the lawyers, and even by the companies. So by making it more complicated to companies, probably we are provoking a deterrence effect in the use of these tools, okay, of these procedural tools. That I think is right. I think it's right, because it's not only making things easier for companies, it's also protecting consumers. And protecting consumers, as we have seen before, in the consideration of the European Court, has a higher level of protection or higher importance than protecting the easiness for the companies to collect their debts. Okay, so it also implies that some kind of judicial intervention is going to be needed here, because who is going to control on the merits the contract? Who is going to control the eventual unfairness of the terms? Only a judge can do this. So in countries where the European order of payment has been given to registries, has been given to non-judicial authorities, this is going to be an issue. This is going to be a problem. And the problem, again, is going to nationalize the European order of payment proceedings. Actually, we have seen it before yesterday, that actually European order of payment proceedings are nationalized already. Okay, because every nation has made some adjustments in the proceedings. We have seen the adjustments in Spain, but this kind of adjustments has been made all over Europe. So the thing is, if we include more proceedings inside the request of the European order of payment, there is a bigger danger for the different countries, for the different member states to include new requirements, to include new proceedings, to include more differences among countries. And this is also something that the regulation itself tried to avoid. I mean, the aim here, the intention here for the European legislator is to make things more similar, not to make things more different. So it's going to be an issue here too. Okay, so for instance, after making the control of the eventual unfairness of the terms, if the court decides that the terms were actually unfair, may the court adjust the claim, I mean the amount of the claim, or have the court to dismiss the claim? I mean, under the Spanish law, the court can decide. I mean, if it is possible to stay, to remain with the proceedings and just changing the amount of the claim by considering not binding the unfair term, I mean, the proceedings can continue, but it is something that the judge can do if the law allows the judge to do. I mean, and it can be a different, or it may be a difference here among different countries, that because some other countries can decide that the existence of the unfair term leads directly to the dismiss of the claim. So these are differences that we have the danger, we have the risk to include into the different national proceedings in European order of payments issue. So I'm about to finish. Okay. As final remarks, conclusions. First one, Bondora judgment has increased consumers' protection by allowing ex officio control of unfair terms in European order of payment proceedings. So, till Bondora judgment, till 2019, no protection of consumers were included into the European order of payment proceedings. Bondora not only opens the door to make this protection, but makes compulsory to make or to assure this protection for court by obliging, by making judges to control ex officio, to control by their own the existence or not of unfair terms in European order of payment proceedings. Second one, so from here we are going to find that we have actually two different European order of payment proceedings. And European order of payment proceedings that treats for consumers, and another one that treats for non-consumers. So when the defendant is a consumer, there is a new set of regulation, a new set of rules that are going to work, and these kind of rules are not going to work when the defendant is not a consumer, when we are talking about conflicts between companies, okay, or between individuals. So, European order of payment proceedings in Spain may make a quick adjustment, just applying what is foreseen for the domestic European order of payment, for the domestic order of payment. this adjustment needs to be done in every country in Europe. Okay, so because this judgment leads to every European order of payment procedure that is issued all over Europe. So unless we do what the Polish courts are doing these days, that saying that they are not binding by the European Court of Justice, I mean, the rest of us that think that, of course, we are binded by the judgments of the European Court of Justice, so need to make some arrangements here in order to adjust the proceedings to this new doctrine of the European Court of Justice. And more broadly, can we consider that the civil procedure itself, the civil procedure as a whole, has changed as a result of the application of the European doctrine on protection of consumers? I think it does. I think that we can say that the principles that we as countries or we as legal system maintain for civil procedure are not the same anymore when we deal with consumers as defendants, and when we deal with situations, with conflicts, when those imbalanced situations are not there. When there is no imbalance service situations for consumers and providers. So probably, I mean, we have here a trend that is being applied in the whole Europe, and a trend that I think is unstoppable, and I think is going to conditionate European and national procedural law in the future. So I'm done here. Sorry, this is everything that I wanted to tell you. I think I adjusted more or less to the time that I was giving, and of course I am open for your questions and for your remarks or consideration, or even critics that you can do it now. So Marcus, I give you the floor again.
Regarding critics, I'm not so sure that we have critics towards your presentation, because it was awesome, it was great. But congratulations, yes, and thankfulness, absolutely. We are totally thankful to have you, to have this lecture from your side, to have the statistics, because it is very hard to find the statistics regarding the European Order for Payment procedure and moreover for the small claim procedure, because I mean it's totally from the practical part, and from the theory there are very little information about it. So we had the honor yesterday to have some numbers from Slovenia, from our team, because she was a judge, you know, so she has access. She has access to these numbers, and also from Pedro, we had also some number statistical, so we can use it to compare the evolution of the procedures in time. And this is very good that you have been able to provide us with this number, and it's very useful. Yesterday, I asked Pedro what to do in order to improve the procedures, because the goal of the European Order for Payment procedure and the small claim procedure is just to improve the functioning of the internal market. So businessmen, individuals, companies from one country can easily invest in another European Union country, knowing that in case something goes wrong, they still can get access to the money. It doesn't matter how much is that amount. But we figure out, Petro saying that for a fee of 100 euros or 150, or let's say, for example, 50, somebody owes him 50, he won't log any file to get his money back. It doesn't matter how easy it is. The form is, and we know the form is very easy. No need for lawyers, no need for translators, no need for legal education. It's absolutely very easy. It is simplified. But still, he said he will be not willing to do it because it's 50, 100, and as when he was a judge, the cases he used to have were very small amounts, basically, and that pushed people not to really go forward it, or for example, to hire a lawyer and to go forward, the lawyer will be 100 times more expensive. So there are some issues. So what's your point of view? How to improve this situation in order to make this instrument very useful and reliable, because that is the goal in order to improve the function of the internal market. What's your point of view? What would you propose?
Well, that's a hard question. I mean, we have a lot of minds
No,
in
that's not
Europe thinking
hard.
about
No.
it. Yeah. Okay. So, I mean, I think that we didn't have the key of the question yet, but probably we have to give up in some things. I mean, it's like this small, very small amounts, very small claims. I mean, probably, I mean, the justice system doesn't work for that, but even the European and the national one. So the justice system doesn't work for 50 euros amount of debt. I mean, it is
Yeah.
not. I mean,
Yeah.
it is not possible to do that. The other thing that I think that that we have to consider is that things are not so simple. Even when we try to do it simple, it is not so simple. And I think in the last hour I have given you the example. I mean, the European order of payment tries to be so simple, and
Yeah.
then we introduce such a tiny thing as how do we protect consumers, and everything becomes so complicated. So sometimes I think the European legislators should be a little more realistic when they try to reduce things to forms, to I mean to automatic decisions, because decisions in law are not so automatic, even when we deal with what we call small cases. Okay, I think that we can improve proceedings by confidence. Okay, because all the enforcement, all the recognition part, I think at some point we should eliminate that part of the proceedings. I mean, all the possibilities to assure or to review again, that I know they have been reduced, but still, I mean, and confidence has nothing to do with legal instrument, but with legal practice. I mean, because I think I have the thought, I don't know if it is right or not, that yet judges and courts doesn't rely so much on judgments or orders of payment coming from another countries of the European Union. So probably what we are doing today, I mean, training, explaining, trying to, I mean, to strengthen the confidence between countries and courts and justice systems, I think it is going to be more useful than trying to make proceedings more simple, because at the end, we lawyers are expert in complicating things. So if we want to complicate things, I mean, the law can be so easy, the law can be so clear that we are going to complicate it. So if we don't complicate it, but when we rely on the other part. Okay, so I think confidence it is very important. I mean, it doesn't help that some countries now in Europe are with this trend of not, not considering themselves binded by the European Court of Justice, or not considering like the European law has a role, higher to the national
Yes.
laws.
Yes.
But this is another question. Making the practitioners aware of the existence of these tools, I think it is useful too. So I think what we are doing here is important.
What about the possibility to make these tools binding? For example, right now there are alternatives, so there are other ways for the consumers to be protected. What about for cross-border debt collection? These tools, the EOP and ESCP, would be binding. I mean, a chance for it to be binding. Do you think it will improve its use among member states of the EU?
I don't know. In Spain, we have this system of consumer arbitration. It's quite common in a lot of countries in Europe. And this is a tool, this is a system that works, I think better than the courts for consumers, for tiny claims. Consumers that, they buy something at a computer and the computer doesn't work and whatever. And or companies that try to bully consumers. Okay, so in these cases, these administrative tools sometimes are better than the justice of the system of justice. Probably an European authority on protecting consumers could be useful in this case. If this authority have an European scope and can and have the authority to enforce the decisions in every country in Europe. And if you as a consumer can go to this authority no matter where you live in Europe and the authority is going to, to make the companies to fulfill their obligations, no matter where they are in Europe. Probably it's more useful. I don't know. I mean, it's
very hard. It's very hard.
Yeah.
Yes.
I know that creating new structures is always, a difficult thing to do, but I don't know. Well, maybe we have to choose what kind of structures we want and are useful. Some others probably are not so useful or are not so important in terms of protecting rights or in terms of making our lives better.